Yeah, once you're live, we can start. It's 11 now.
Yes.
Done, sir. Live now.
Yeah. Right. Yeah. Once you're live, we can start. It's 11 now.
Yes.
Good morning, everyone.
Done, sir. Live now.
Yeah. Good morning, everyone. Welcome to the World IP Day Celebration Expert Talk. Myself, Dr. Ilangovan Kariyappan, Assistant Innovation Director, Ministry of Education Innovation Cell. On behalf of Ministry of Education Innovation Cell, AICTE and CBSE, I welcome you all for this World IP Day celebration, and they also welcome you for this expert talk. Today we have with us Professor Rao, sir. We have Mr. Divyanshu. Now I would request our Director, Ministry of Education Innovation Cell, Mr. Yogesh Brahmankar, sir, to give a formal welcome note.
Very good morning, everyone. Thanks, Dr. Ilan Govan, and welcome to everyone for this World Intellectual Property Day celebration. I also welcome Dr. Rao, Professor from IIT Delhi, and Mr. Divyanshu Mishra from Government of India. Both of them are going to not only motivate, encourage you, but also going to discuss why and how of intellectual property. I was just discussing something with my colleague who is here, Mr. Pradeep Dage, who is also an IP expert and who is assistant director with us, and came across something that we Indians have actually very good capabilities, but we do not document. Yeah, and this has been in discussion maybe years and years and years. But now it is, I think, beyond documentation. It is about are we protecting our innovations? We should innovate openly, but then if we do not protect, we cannot commercialize it. And if we do not commercialize properly, we cannot actually make any impact. So many innovators, they have some misconceptions that I really want to do something for society and I want to have a big impact, but I really don't want to go for patent and all that. I think these are some misconceptions. I would request Dr. Rao to talk on why, how patenting, or not only patenting, having any kind of intellectual property, maybe a copyright, maybe a design patent, can actually enhance and increase the impact. Because we as students, faculty members, researchers who have joined here, they actually have very good intent, they have capabilities to innovate. But then sometimes we actually go into a false dilemma. I'll say it's a false dilemma where, no, I really want to do it for society or an impact. But then actually we actually reduce the level of impact by not actually going for intellectual property. And I think this is the focus, and this is where we thought of celebrating this day with the experts, Dr. Rao, Mr. Divyanshu, and then Mr. Pradeep, my colleague. He is also going to talk on more of action. So this is more of an interactive session where, of course, they are going to give you some tools, techniques, but then we will have some Q&A. So there is a team which is actually monitoring your questions on YouTube also. And then we will have some interactive Q&A session also at the end of it. With this, I really, what I'll say, I welcome everyone, and let us come out of our comfort zone and let's start making an impact with focus on intellectual property. And I hand it over to Dr. Ilan. Take it ahead.
Yeah.
Yes, Dr. Ilan, you can take it ahead.
Thank you, sir, for your welcome and extending your support for organizing this event. So it's our pleasure to inform you that this occasion, Ministry of Education Innovation program for IP literacy and awareness. Through this program, fees reduction for filing and examination fee. In this, and we had a patent amendment rule of 2021, and through awareness of Kapila and NIPAM, the overall patent filing in academic institution had increased to 200%. We want of celebration of World IP Day that Indian patent filing institution 47% from 2018 to now. Thank you all for your support for that. Now I'm grateful to invite our expert speaker, Professor Madhusudhan Rao from IIT Delhi. A brief about Professor PVM Rao sir. He is a professor in Mechanical Engineering and Design Department at IIT Delhi. Professor is a co-founder of Assistek Lab, which works towards the development of assistive technology for empowering of visually challenged person. As a coordinator of IIT Delhi Design Innovation Center, Professor is also responsible for initiating and driving multiple programs in design, innovation, and entrepreneurship. Professor has more than 20 plus patents and designs to his credit, many of which have been commercialized. Professor and his teams have been translation research effort have led to successful products and solutions which are presently in the national and international market and have made a big impact in the market today. He also served as a part-time director and scientific advisor to many startups and incubators. Professor was a guest researcher at US Government National Institute of Standards and Technology 5 times, and he was also a visiting scientist at Institute of Technology and a visiting professor and member of Stanford University. With this brief introduction, I request once again Professor PVM Rao sir from IIT Delhi to address the participants today. Sir, the platform is open to you now, sir.
Good morning, and good morning to all the students from schools and colleges, the faculty and teachers who have joined for today's very important day, which is World Intellectual Property Day. Thanks for joining. Before I start, I would like to congratulate all the citizens because this is the first time in this financial year, India actually granted more than 1 lakh patents. So we reached that milestone of 1 lakh patents in the financial year. And I think the number of patents, number of intellectual property which have been filed by most of the people, most of the Indian citizens and in India has been increasing continuously. And so that's also a good time to celebrate. However, I think we need to do much better. So this number actually looks very attractive, but I think is not sufficient for a big country such as ours. What I'll do is I'll give you a few stories. Many of them are actually real stories, and try to convince you why is intellectual property is extremely important in today's time. We were asked to speak on 2 aspects, why and how of intellectual property. I would be covering more of why, and my next speaker, Mr. Mishra, will actually also cover more on how aspects of intellectual property to do that. Okay, so let's start with, I think I basically made my presentation more in terms of incidents and stories so that students can actually relate to there. Okay, so let me start with the first one. So Rajini is a college student and she is a great innovator. So she comes up with this brilliant idea of how to clean utensils without water. Generally, we clean our utensils with water. She has a new idea that they can be cleaned to a required level without water. And what she does is she demonstrates this idea by building a model or a prototype to most of the community to prove that, hey, this idea actually works. But however, she does not file any patent or protect her idea through intellectual property. Now, what happens next is she sees that after 3 years, many of the companies have used her idea and actually made products and solutions and also made big profits out of that particular idea. Though idea came to Rajani first, but I think the actual benefits went to some of the companies which made products out of this particular idea. So she realizes and probably repents that she lost a very big golden opportunity to make money for herself, or maybe her school or college, or even for her country. Because why I'm saying country is that many of these companies which are actually are making are not located in India, but they're actually making products outside and selling in India. So a kind of an opportunity lost for Rajani. And this type of situation is very, very common across the country. So the first thing, a first lesson is that whenever you have a great idea, and even if you are able to demonstrate it, not necessarily by building the working prototype, even a prototype which is more like look alike or work alike, even sometimes the simulations or sketches are enough for you to protect your idea by filing a patent. And I think all of you, India actually, as it was said, has a great potential to innovate, but sometimes not filing a patent is actually hurting a lot of us. But I'll also give you some examples where some of the people are smart who probably did better than Rajani. So the first example which I'll give is most of you have seen the vernier caliper. Most of you may have used for measuring. So vernier caliper is used to measure dimensions, thickness, diameter. It has two scales. One is main scale and vernier scale, using which you can actually do many of the measurements fairly accurately. Now, what happened is two of the students, their name is Pranay, who is on the left, Anshul, who is on the right. They were actually visiting a school and found that there are many students who are using the vernier caliper. And they also found that among the students, there were a few blind students. And these blind students were not able to use vernier caliper because how will you see these markings on the main scale and vernier scale, even if you want to measure independently? So they thought, should there be a vernier type of an instruments for people who can't see, who are visually blind? And then they came back, they started working on that idea and came up with this, which is called as a Braille caliper. So what does Braille caliper do is it's a device which is similar to a vernier caliper. In vernier caliper, you do the measurements by seeing, but in the Braille caliper, you actually do by touching, which visually blind students can always do that. So it has two scales, main scale, which is also in Braille. There is a vernier scale, which is also in Braille. Whenever there is a movement, you have Braille pins which move up and down and give you a fairly accurate dimension of this particular thing. Now, this idea came to them when they were still students. So they thought what to do next. They actually built one of the prototypes using 3D printing, took it to people and saw that it's working. But one good thing which they did is before they go to outside world, they wanted to protect, and they filed a patent both in India as well as in one or two other countries like United States to protect their intellectual property. And that actually greatly helped them. Now, how did it help them is, of course, this was a great innovation. They also got an award, which is called Touch of Genius Prize for Innovation. And this money also gave them to make more products. They thought they'll actually commercialize it. Commercialize means I'll actually produce in large numbers and sell it to people. They were still students. Their fathers were still working. So they thought both their mothers were housewives. So they founded a company in the name of both the mothers. And then they started producing this and started selling this particular product. Since they filed, patent in United States also, they had a protection not only in India, but in the countries such as United States. So generally what happens is you have a protection in all the territories where you actually file a patent. And if you have a really great innovation, you should not restrict to India, and also think about filing your patent in other places. And that's what Pranay and Anshul did. And finally, they made a lot of money. And it's not very common for students to make a lot of money with a great idea, but they did it. So that was a good example they could do. They were not like Rajini, just because they did file a patent, and it did help them to do. Next story is Rajini got another opportunity to basically, she got another very innovative idea. This time, she came up with a very novel mosquito repellent, which can be used without electricity or power. Most of the mosquito repellents, either while using or you need to charge in order to do that. But she came up with a very interesting chemical-based method with controlled evaporation to actually repel the mosquitoes. And this was a great invention. And she demonstrated this idea is in a big exhibition. And most of the people appreciated the idea that this is a very novel and innovative. This time, she decided to file a patent. Last time, she didn't file. This time, she decided to file a patent. But what happened is that in spite of her idea being novel, she did not get a patent. She did not get a patent because before you file, you disclosed your invention to most of the world. So world knew about your invention. You get a patent only when you don't disclose before you file it. And she had a second great idea, but another lost opportunity, just that she disclosed it to the public at a large and lost this particular opportunity. So this is a second major mistake which most of the people do, that they have a very great innovation, invention, but they show it to all the people and get even awards and prizes, recognitions, but then it is very too late for somebody to file a patent. So that's another thing which most of the students, faculty from schools, colleges should keep in mind, that let me file a patent before I disclose is a very, very important aspect. I'll give another real story where this did not happen. There is another innovator by name Pankaj. Pankaj is from a city of Baroda. So Pankaj is again a very great innovator. So he just graduated and wanted to do something for the benefit of society. He wanted to be an entrepreneur. And he was looking for what is the problem he should solve. So one of the problems which he realized is what you see in this particular picture. Most of us, or many of us, may have gone through this situation where we had a plaster either in one of our limbs or other places for a few weeks, sometimes for a few days to a few weeks. Now, the problem with this type of plaster or a cast is that when you're actually putting it for very weeks, it's very irritating to have this. It's sometimes very heavy. After some time, it gets soiled, becomes dirty, and it is infection prone. You cannot clean it. Then the skin which is below this particular plaster, the plaster also gets affected very seriously. So the cast or the plaster is not washable and breathable. So he thought, why not? Why should not we have an alternate plaster, which actually, see, the role of the plaster is to see that your limbs are not mobilized. They are in the same position. There is no mobility for the limbs which you are actually trying to arrest. So if you're able to achieve that by alternate route, you can still have. So he came up with this, which is called as Flexi OH, which is the name. And what the Flexi OH does is it has a very rubber-like material, and it's a very flexible. You can actually put it on any of the hands or legs because it comes in variety of shape, sizes, depending on the limb. And you can also put it in place by a zip. Once you close the zip, it is in place. But you know, the flexible material like this cannot arrest. They actually cannot make your limb immobilize. So what is generally done is in this particular plastic thing, in this particular rubber-like material which you see, it is also filled inside with a liquid, which is more like a thermosetting resin. And once you put it on the hand of a patient, then you actually heat it, like if you can see at the bottom, infrared heating, which is being done. Once you heat it, that liquid which is inside this particular cast becomes a solid, and this entire thing becomes like a rock solid. Then it actually kind of prevents any mobilization of the limb, etc. So he came up with this idea, but good thing is he also filed a patent before he wanted to commercialize this. And again, in a couple of countries, both in India as well as this thing. So this is like a cast which is worn by a patient. This is like the patient being, actually this is being put on a patient, and this is like a heating which is done. The good thing about this is washable, this is breathable. It also allows you to do many things, like with this type of a cast, you can do swimming, you can play tennis, you can do many other things, which otherwise is very, very difficult with the normal cast. And good thing which happened to Pankaj and his team is that this product has become a big success, not only in India, but in rest of the world. So even in countries like Mexico or Sweden, there are people who are actually using this cast instead of the normal plaster. That also means Pankaj is a rich guy now. He made a lot of money through these products, etc. So you have seen that how filing a patent becomes a very important and a precursor if you really want to get a commercial benefit out of these aspects. So which is very, very important. And that's a lesson for all of us. I'll just give my third one, and then probably we can have some discussion. So Professor Rahul Gupta is a faculty member. So he invents a new water filter. This water filter, the advantage is that filtration of a water takes some money. Every liter, there are certain paisa which you have to do. But if you can actually do the filtration in 1/5 or a 1/10 of a cost, a lot of money can be saved. And that's what Professor Gupta did. And once he found that it is working, he decided to sell his technology to industry. But then when he went to industries to sell his idea, many of the industries were not ready to take his idea. Very few industries came forward and said they will buy his technology, but will give only a very meager money or just a peanuts for this type of an invention. The realization which Rahul Gupta had is that he went to the industry without protecting or without filing a patent. When you don't file a patent, industry would not like to buy your technology, because if I take your technology and actually commercialize it, invest the money, make it a product, take it to the people, what is the guarantee that others are not going to copy the same idea? So that was the reason many of the industries did not come forward to take this particular technology, because intellectual property was not filed. And you went to industry to basically take this. This is another big mistake which most of the faculty members in India make, where they don't protect, and then they want to convert research into products and solutions. In fact, a lot of people, whenever they come up with this, they immediately write a research paper out of that. And writing a research paper without filing a patent is also losing your intellectual property. The moment you write it as a research paper, then it is a public disclosure, and you won't get a patent for this particular thing. And it is very rampant in India. I wanted to show you with some data because there are many school teachers and college faculty are available here. So I think world does a lot of research in an area called nanotechnology, and they also file patents. I'm giving you a data of the year 2019 of the various countries. India was the third best in terms of writing research papers after China and USA, as you see in the second column, where the number of publications in nanotechnology which came from India is shown of various countries. But look at the third column, where the number of patents which were actually filed and published in this area is very, very meager. In fact, in terms of the ranks of patents, we are not big, particularly in this particular area of nanotechnology. Now, what happens is if you publish a lot and don't file a patent, you have lost an opportunity to commercially sell your new technology or a new idea or a new invention to rest of the world, and you don't make money. So most of the countries follow this very rigorously because they want to increase their GDP by filing more and more patents and then commercializing these patents not only in their own country but rest of the world. So this is another great important lesson for India, why we should actually go for filing a patent. So generally, if I have a patent and I know that this has a lot of value for industry and public and society, then I actually transfer this. Either I can have my own startup to convert this patent into a product and solution, or I can transfer it to another organization like an industry or a company to make a product out of this particular thing. So this is generally done through an agreement, which is generally called as a technology transfer agreement. So there are two aspects. One is which is called as a ownership transfer. Ownership transfer means that I give my complete rights of my patent to another organization. Complete ownership is transferred to another organization for a certain amount of money. That means that you lose your ownership. The organization which is actually buying would start owning is this thing. Second aspect is the licensing. Licensing often happens where I don't give the ownership, but I'll give you permission to use my patent for commercial. And in view of that, the company has to pay a certain money to the owner of this particular patent. And we did that in one of our products where we sold more than 1 lakh. The 5% of the sales actually came to us, and we got like more than about 1.5 crore rupees as a licensing fees for one of the products which we built a few years back. So that's another thing which people should look at. Also, I just wanted to quickly clarify between, I think these are some of my last slides, the difference between owner and inventor. Owner and inventor can be very different. In some cases, the one who actually owns the patent is, or ones who invents the patent can also be owner. For example, take a big company where an employee comes up with an idea. Often the owner is a company and inventor is somebody who came up with an idea. And the owner is somebody who can actually commercialize. In institutes such as educational institutes, institute is the owner, inventors are the faculty students. But whenever the money comes, or whenever technology transfer happens, a percentage of money is given to faculty and students. Like in our institute, we get 60% of the money to faculty and students, and 40% goes to the institute. And last of them, and many people say, is there any limit to filing the number of patents, etc.? Actually, there's virtually no. I am just showing you a list of the top 10 people who have filed maximum number of patents. And if you really look at, this was a data taken some time back. So there are people who filed like 4,000, 3,000 patents too. And very notable among them is one on the number 5, which is Thomas Edison, which all of us know. Thomas Edison himself has filed more than 1,000 patents. A good news is that very recently, one of the Indian researcher exceeded the number of patents filed by Thomas and moved to the position 4. So Gurtej Sandhu is a US based, but an Indian number, and he has filed now 1,000. He did his master's from IIT Delhi some time back. His this thing. Okay, I think, do I have 2 minutes or should I close?
Yes, sir.
Okay, 2 minutes, okay. So, I think in India, there are 7 types of intellectual rights. I think Mr. Mishra is an expert in this because he handles all these type of a thing. He'll tell more about it. I just wanted to close by giving two examples. Just so other than the patents, industrial designs are also very important. If you really look at a device which we came up sometime, this was not eligible for a patent because this did not have any novelty. But if you really look at this particular product, it had a particular color, a combination of keys, an arrangement of keys, and the layout of these keys, which had a lot of usability, which is very usable product. So whenever you don't have an invention, but you have a new design, a color, form, configuration, a combination of many things, you should also protect it as an industrial design. Why is it important is, if you don't protect, if someone comes with exactly same device, which is a fake device, you can't actually prevent them from selling it. And all of you know that particularly in the market, there are many real products and fake products. You can only prevent fake products which resemble like the actual products can be prevented only when you have protected it through an IP, which is an industrial design. So industrial design is also an important aspect. And we do file industrial design at the last stage. Like for one of the product, it went through many iterations. Iteration 1, the version 2. When we come up with final version, then we file the intellectually. Patents are filed very early, but I think designs are filed during the last stage of this thing. And lastly, trademarks are very important. For example, this is a logo of IIT Delhi. And because since we have a trademark, anybody can't use our logo. If we don't have, our logo is free to be used by anyone else. And it's also now a big brand. So you want to protect your logo through another type of an intellectual property, like a trademark. Thank you. And I hope you got some idea why filing IP is extremely important.
Yes, sir. Thank you, sir. We have noted few questions, sir, in the chat box. There is a student from a final year is asking that if I have a patent, how it will be useful for pursuing my higher education or initiate my startup? How it will be useful to him is asking, sir.
Oh, wonderful, wonderful question. So if you really look at the examples which I gave, Pranay, Anshul, Pankaj, who are also students, one thing which we have seen is the people who have filed a patent and who have actually gone through a process of invention or innovation are extremely respected in all types of careers, whether it is higher studies, whether it's industry, or whether you go for a startup or anywhere. So people think that somebody who has gone through this experience is extremely valuable for that organization. So whatever career track you choose, you have a great advantage if you have a prior experience of filing a patent.
Yes, sir. So there is a faculty from an higher education institution is asking that if I have a patent, whether it will be helpful for me in securing funding from funding agencies like DST or AICTE or DRDO. Anywhere do we get an opportunity, or how it will impact for my securing my funding? So that's what.
No, I think what when you go to government funding agencies, they also see that what you are trying to do has a novelty. So it's an establishment of a novelty for them. And if you go to, for example, other people, for example, an angel or an investor, they would be very happy if you have a patent, because when they invest a huge money in your idea to take it to market or commercialize, they also want to see that there are returns. If you don't have a IP, there is a very high risk for the investment. So any investor would be very happy if you have, and government agencies would be very happy that you have done this thing and you have shown that there is a novelty and also a great utility of your product, and there is a merit in funding this particular aspect.
Yes, sir. So there is a school teacher, sir. She is asking the basic questions, that is saying like how she can identify which should be patented and which not to be patented.
Yeah.
So
Yeah, I think that is a little tricky process. Maybe Mishra ji will also tell a little bit after this. One of the things is of course, you can always one thing is first search you can do yourself. For example, what I do is when I look at something, I go to patents.google.com and search for patents in that area and see if there are any patents. That may be a first. But I think there are patent databases, and there are people who can help you search to know whether your patent has a novelty or not. So somewhere you should basically tie up with that. And I'm sure government also has many opportunities for that. For example, most of the colleges would have are now establishing intellectual property cell, where this intellectual property cell helps you to establish that what you are actually trying to, what like your idea or whatever is your design has something which can be protected by intellectual property.
yes, sir. Thank you, sir. Thanks for sparing your valuable time in spite of your busy schedule to address the participants. I would like to extend my heartfelt gratitude for your remarkable address and highlighting about why IP is important, how it is benefiting the students, innovators, and faculty members. With a few case studies of Rajani, I'm sure it was uh, a good opportunity for everyone, sir, including me. We got an opportunity to know how important patent filing is and why we should do it. Thank you, sir. Thank you once again for sparing your time and addressing the participants who have joined online across the country. Thank you, sir.
Okay.
Thanks
Thank
for
you.
your time.
Thanks, and all the best to faculty, teachers, students, and others on Intellectual Property Day. Thank you.
Yeah. Yes, sir. Thank you, sir. Now I would request Mr. Divyanshu Mishra, Assistant Controller of Patent and Design Mechanical Group of Patent Office, Delhi. Before I request him to address a brief profile about Mr. Divyanshu Mishra, serving as an Assistant Controller of Patent and Design at Patent Office, New Delhi. He is specialized in mechanical engineer. Mishra had joined patent office in 2016 as an examiner of patent and design. Mishra ji is also an authorized officer from WIPO, and he is a trainer of NIFAM. Many of you would have been seen him as a trainer at your campus in online and virtual or physical mode. With this brief introduction of Mr. Mishra, now I would request Mishra to address the participants. Sir, please, the platform is open to you now, sir.
Yeah. Am I audible, sir?
Yes, you are audible, sir. Please go ahead, sir.
Yeah. Okay. First of all, thank you, Dr. Elan, for the invitation. And good morning, everyone. Happy World IP Day to everyone. And especially thanks to Dr. Rao for the previous session. He has made my task much easier because he has articulated the importance of IP in such an easy and illustrative manner. Because examples are the best way to explain anything. So the audience will be greatly benefiting by those examples because they are real examples at the end of the day. Okay, so now what I'll be doing is that I'll be talking about the administrative aspects. That is, once you have an invention ready with you, what is the procedure to obtain a patent over it? But before that, in the initial 5 or 10 minutes of my session, I'll be very briefly touching upon other kinds of IP apart from patents which exist there so that one can distinguish between different kinds of IP because some of them are actually overlapping in nature. Yeah, so I'll be beginning with a very brief introduction about the intellectual property. So there exists a concept of intellectual property in our society. So one thing anyone should be very clear about why, because this is a man-made concept. So why does this exist? So there are there are several rationales actually, but these two are the most famous ones. One is the labor rationale, and the other one is personality. Once someone has invested some sort of intellectual labor into a product, someone has come up with an inventive product. Definitely one thing that he would be wanting is recognition. Other thing, if possible, some sort of commercialization and monetary benefit. Then another sort of creation could be a creative one, a story, a poem. So in a way, we can say that the creative works of any author are an extension or a reflection of their personality itself. So there should be some sort of framework existing which secures that these creative works of theirs are not tampered, altered, modified, or monetized without their knowledge, acknowledgement, permission, or taking them on board. Okay, so these two are the rationales why IP exists in our society as a concept and as a legal right. Okay, benefits are quite obvious. Once you have created something useful, you can gain recognition out of it, you can commercialize it to gain monetary benefits. As far as categorization goes, the entire intellectual property is broadly divided into two verticals. One is industrial property, which entails within it patents, industrial design, trademark, GI, and several others. This list is by no means exhaustive. There are various other IP types as well. And the other very broad vertical is copyrights, which in itself comes with bundle of associated rights, like rights associated with broadcasting, translation, etc. Before we begin to dive into the prosecution processes of the patents, one thing everyone should be very clear that most of these rights are territorial in nature. That is, you need to protect them in all the countries where you think there is a potential market for them. Okay, and some of them are for limited term, like patents, designs. They are for limited term, and you need to pay renewal fee time and again to maintain them for that limited term also. Another important thing is there is no automatic relief. That is, once you have been granted a patent and you see that there is someone who is infringing upon your patent, so the affected party needs to approach the required court, and thereafter they can seek an injunction or appropriate relief. And another very important thing is there is an element of quid pro quo. What I mean there is that suppose you have come up with a product, so you can't get a patent over a product as it is. There is a precursor to that as well. That is, you have to explain to the society in general and patent office in particular that how you have come up with product. There are several requirements under the Patents Act, and these requirements are quite universal. They exist across all the countries in the world. That is, you have to explain your invention in sufficient detail. there is a requirement like sufficiency of disclosure. These kind of things also exist. So you give something to society, and in return, you get a monopoly for a limited time over these rights. Now, I'll be going to next slide. So what I'll be doing is that firstly, I'll be covering industrial design, trademark, and GI, and then we'll be focusing upon the patents. So industrial design, I would like to explain this in a very layman manner. Suppose you are in a marketplace and buying a ceiling fan. Okay. Now the brand is not a consideration for you, neither is cost. Now suppose there are 3 ceiling fan in front of you with similar cost. Then definitely your choice will depend upon which fan looks better as in visual or ornamental aspect. So obviously someone at the back end of that particular fan is investing some sort of intellectual faculty to come up with their peculiar design, which is appealing to the users or buyer's eyes. So to protect these kind of intellectual investment, there is a kind of separate IP, which is designated as industrial designs. So as you can see on your screens also, this is a legal definition that it is an ornamental aspect of any article. I think this from this picture, it would be more clear. So these kind of aspects wherein the design, the appeal, the ornamental aesthetic value of the product itself leads to the purchase of that product. That kind of aspects are protected through industrial designs. Then we'll be going to the next important kind of IP, that is trademarks. So trademarks, a rough idea everyone would be having that these are kind of logos which represent a particular manufacturing or service industry. Okay, but what it actually means that it identifies the source of origin or goods or services. That is, once you see that this tick mark, you understand that this particular footwear or apparel is coming from a very specific company, which is registered under the name of Nike, and so on and so forth. So like for industrial designs, we have a limited term of 10 years, but for trademarks, there is no limit over the term. It is 10 years at a time, and you can renew it indefinitely based on the payment of a renewal fee. Now, there are several requirements for trademark. Okay, one is it should be distinctive. When I mean it should be distinctive, the simplest example is like Apple. Apple is a very famous trademark, but it has nothing to do with electronics. If you consider the word Apple of the English in itself, okay, then it should be non-deceptive. When I mean what I mean by non-deceptive is it should not be identically or substantially similar to an already existing trademark. That is, you should not be trying to free ride on someone else's reputation. Okay, so that is in the sense that it should be non-deceptive. It should be capable of being represented graphically, because this is a legislative requirement, and that is the reason why some sort of olfactory or some sort of smells are not allowed to be trademarked in India. There are jurisdictions where even olfactory marks are required. So that is what it means to be capable of being represented graphically. And it should be non-descriptive. Like you should not have H2O as a trademark for some mineral water company. Okay, so some sort of arbitrariness should be there. And the benefits of trademarks are quite obvious. It evolves into brand reputation, public goodwill, these kind of things. Okay. And all these IPs are governed by a different set of acts and rules of Government of India. So for trademark, we have Trademark Act and Rules 99 and 27 respectively, these kind of things. Then let's go to geographical indication. So if there is a product and the speciality of that product is mainly due to the geographical location from where it is coming from. Now, this speciality could be because of the natural or climatic conditions existing therein, or it can also be because of the expertise of artisans therein. Then such kind of intellectual abilities are appreciated and protected through another kind of IP, which is called geographical indications. Okay, so you can see these kind of things, Darjeeling tea, Makrana marble. So these all are GI tagged products. Once you have a GI tagged along with a marble, let's say Makrana marble, so you know that this particular marble has a particular sort of quality and originality associated to it. That is the importance of GI. Then let's come to another very broad vertical, that is copyrights. So copyright in itself is a bundle of rights, as I've already explained. Suppose you have written a novel or a short story, then translation of the short story into any other language, or depiction of this into a motion picture, all these rights also subside with you. And that is why copyright is often also referred to as a bundle of rights. Then this is an automatic right. What I mean by automatic right is once you have expressed your idea, and the legal term for that is fixated your idea into some form. This fixation could be in the form of you writing down, jotting down your idea onto a paper, or fixating it into a digital form like floppy, pen drive, or any other such form. Then you have copyright over that particular thing. Registration on the copyright is optional, but obviously it would help if there is some sort of dispute in the future. Okay, so these are important things. The requirement for copyright should be that it should be original. What I mean by original is that you should be the author should be the creator. That particular work should be originating with the author itself. Okay. So these are different kinds of works over which there is copyright provided under Copyright Act of India. So there are 6 kind of different works: literary, artistic, musical, dramatic, and the examples of the what falls under what category is also provided in the slides itself. So like for literary works, poem, novel, drama, table, computer programs. Computer program is an important one. It also falls under the literary works itself. Okay. So the slide is self-explanatory. Most of the creative aspects of your mind are covered by copyright. The term for protection are quite extensive for copyrights as visible. For literary work, it is life of the author plus 60 years, and so on and so forth. So these are quite, but they are limited. This one needs to keep in mind. Now let's come to the main aspect, focus of our this session, the patents. So patents, the utility of them has already been explained by Dr. Rao in the previous session. I will be touching upon how to get it and what it exactly means. So there are 3 or 4 keywords which one should keep in mind when talking about patent. It is a kind of right which is granted by the state sovereign to an applicant. Okay, and since a sovereign or a state or a country is granting this right, they are also territorial in nature. That is, this right is only applicable within the confines of that particular territory where it is granted. They are limited in tenure, which is 20 years in case of patents from filing date. And it is exclusive right, so to say that it is a negative or monopolistic right. Once you have a patent over an invention, you can prevent others from copying it, infringing upon it, and you can enter into licensing agreements, assignments, those kind of things. And these are granted for inventions. So invention is defined under Patents Act 1970, and roughly translates into your product should be new, should be non-obvious and useful. We'll be touching upon these aspects briefly in a little while. And a quid pro quo element is there, which I have already explained, that you have to define your invention in sufficient detail so that persons involved in that particular field can actually work upon it to build something even better. Okay. So that is the whole purpose of sufficiency of disclosure, which one needs to understand. Okay. So now you have an invention ready, you want to file patent application in India. So there are several forms which one needs to file. These forms are more than 31 as of now, but these 5 forms are quite essential and they need to be filed with every patent application in India. So first one is Form 1. Form 1 simply consists of all the information of the applicant, the inventor, if they are authorizing some sort of agent to proceed with the application, that patent agent, the title of the invention, the inventor. So it would be better if I show you the Form 1. So this is Form 1. You can see first application. This has been recently amended in the March itself. So first entry is what kind of application it is. So this I don't think is within the scope of this session. There are several kind of patent applications which you can enter with, but let's say it is an ordinary application for time being. Then there is applicant details required. Applicant can be an entity and applicant can be an individual as well. So one needs to understand that an inventor can only be an individual in India, but an applicant can be an assignee of the inventor or that inventor in himself, herself also. Okay, so that is why there are 2 different columns. One is for applicant and one is for inventors. In case both of them are same, then there is this option already asked, are all the inventors same? And you need to click tick over yes over here. Otherwise, there should be signatures of the inventors mentioned in the column 4 at the bottom of this form, so as to say that they are assigning their rights to the applicant, and the applicant have all the right to proceed with the prosecution of this application in the patent office. Thereafter, you have title. Then several applicants prefer to go with patent agents to proceed with their applications for various reasons. So those details are required herein. Then this address for service of applicant is required. The email ID and mobile number becomes quite crucial because most of the proceedings of IP office these days is done in complete virtual mode. Okay, so these are essential. Thereafter, here you need to take the appropriate boxes, and this is all about form 1. Then there is form 2. So what we normally call patent document, that is nothing but form 2 in the Indian context. This form 2 is where you describe your invention. You begin with the title. Thereafter, these are. So what I'll be doing is I'll be showing you a sample of form 2 also, so that you have a idea. So this was an application, multi-utility logging. So this is the first page of form 2, and this form 2 is actually the description of your invention. In legal parlance, it is called complete specification. So this is the extension of your form 2. So here, first of all, this is a prototype or how a patent document looks like. So first of all, you go with the field of invention. Thereafter, briefly, you describe the technical background of the invention, then objectives of the invention, summary of the invention, brief description of the accompanying drawings, these kind of things. Then the detailed description, here in which I was already emphasizing that sufficiency of disclosure. So that aspect comes in handy in here. Detailed description of the invention. Here you need to explain your invention in proper detail so that any person interested in that field can actually come up with that invention of yours by reading this description of yours. Okay, thereafter comes the most crucial part of any patent complete specification, that is the claim. So in the description part, you will be explaining all the things. What was the background art? What was problem existing in the background art? How are you trying to address those problems? What are the comparable solutions and how yours is better? But when it comes to claims, therein, these are the parts over which you are going to gain monopoly or exclusive rights over. So there are certain requirements which you need to adhere to while drafting of claims. That is, they should be very clear, they should be succinct. So the features of invention, suppose you are coming up with a, let's say, an engine. Okay, so the specific features of that particular engine, what kind of engine it is, what are its various embodiments, what are different sides of your engine, these kind of things need to be there. The benefits, the advantages, these things need not be present in your claims. Like you can see, if you read the multi-utility logging plan, and thereafter they are simply enlisting the very specific limitations of that particular logging bag. Whereas in the description, they have explained all kind of things like comparison with the existing ones, advantages, these kind of things. Thereafter, there's an abstract and then the drawings. So all of these are governed by several guidelines and legislative requirements. And for that, there is a patent manual, Indian patent manual. And therein chapter 5 of it can come quite handy for someone who is trying to apply patent on their. I would recommend that anyone who is trying to apply patent on their own, they should go through chapter 5 of patent manual once. Okay, then there is another form 3. So as I've already explained that these rights are territorial, and sometimes you may feel that the potential or the market of invention is rather global or rather multinational. Then you will be going for patent applications in different countries. So in such cases, you need to provide those details in this form 3. In case you haven't filed anywhere else, you need to supply information in the form of not applicable on nil. Okay, then form 5 is declaration as to inventorship. So I have told you that applicant and inventor can be same or different entities in different cases. So if the applicant and inventors are different entities, then there is the requirement of this form 5, wherein applicant gives a declaration that this is the invention which have been assigned to me by these particular inventors. They were the inventors in the first place and I have taken the right from them. And then this form 1, 2, 3, and 5 are regarding the application of a patent application. But applying a patent application, getting grant of a patent application. These are two steps, but between these, there is a third step which is required in the Indian system, which is Form 18. That is, you need to file a request for examination with the patent office, and only once you have filed a request for examination, you can get that application of your examined. Once it is examined, then only it can be adjudicated whether it satisfies the criteria of patentability, whether it can actually translate into a grant. So the time period for your request for examination, which has now been brought down to 31 months. So earlier it was 48 months till 15th of March, but now suppose you have filed today itself, then within 31 months you can file for request for examination as well. So this one needs to understand that there's a distinction between application and request for examination. And this would be more clear by this particular slide, wherein the fees for these two forms is also prescribed. So Form 1 for filing a natural person or an educational institute, which I believe many of the stakeholders are present here. So for them, the application fee for filing a patent is 1600, and there is 4000 rupees fees required for request for examination, which is done through Form 18. So you can see that government is incentivizing educational institutes with much reduced fee as compared to companies and other entities. And how to apply? So both kind of applications are possible, that is physical and virtual, but government is also incentivizing the online mode of applications, wherein they provide an additional 10% discount over the filing if you are doing this in virtual mode. So this is a module through which it is quite easy. You can create an account and then you can upload all the relevant document, pay the requisite fee, and can proceed with. And the entire end-to-end operation of patent application as on date is completely virtual. So right from the beginning till the very end, wherein you attend the hearing, all those kind of things are done virtually or in online mode. So you need not to visit the offices physically for patent grant in India, provided all you fulfill the statutory requirements. Okay, then as I have already told that once you apply for an application, there is 31-month window for filing a request for examination. Once you file an application, there is an 18-month cooling period. Only after that your patent application is published in the patent journal. Once it is published, public at large is provided with a time period of 6 months to scrutinize it, and there is a provision of pre-grant opposition as well in case public at large, any person in the public feels like this thing is already present in the public domain and this need not be granted as a patent. Okay, so 18 plus 6, 2 years time period is there, which essentially every patent application will have to go before it can go to prosecution stage, as in it can translate into a grant. So there is another provision brought by a government a few years back, which is expedited examination, and it is applicable to certain entities, and the list of these entities is provided under Rule 24C1. So some of the relevant entities for this session, which I have already provided here. So a startup, a small entity, if all the applicants are individuals and one of them is female, then any department of the government or institutions established. So these are several sub rules within Rule 24C1, and these kind of entities are eligible for expedited examination. So what is there? They can jump the queue, okay, because these applications are examined on first come first serve basis, but by paying some additional fee and for selective eligibilities, you can jump the queue, and there are relatively stricter and smaller timelines for such kind of examination. Okay, so an institution wholly or substantially financed by the government, these kind of entities are eligible for expedited examination as of now. Now let's go to, once you have filed your application, how does it proceed in the patent office? What is the workflow in the patent office? So you have filed, supposing that you have filed an application and request for examination as well, and after 18 months it is published as well. Now it will be assigned to an examiner in the patent office for examination. So the examination by an examiner is done on two premises. First one is formal and another one is technical. So as I have already showed you, Form 1, 3, 5. So there are several formalities required while filing a patent application. So assessing those requirements, is done through formal examination, whether all the whether applicant have been proper assignees, are the inventor signed there, if there is authorization, are the agents properly authorized. These kind of things are checked in the formal examination. And then we come to the technical examination. So this is the heart and soul of patentability as far as India is concerned, or any other jurisdiction either. So three major requirements which are adjudged in technical examination are novelty, inventiveness, and industrial applicability. So novelty in itself means that whatever you are coming up with, it should be new. New in the sense that it should not already be existing anywhere in the globe in some form. And that some form should be a single entity. So it should be new to begin with. Now, once it is new, the other question arises is whether this newness could be predicted by someone who is already in that field. Okay, that is, suppose there is A, there is B, you are coming up with C, and someone who has knowledge of A and B can very easily predict the features of C, which you are actually claiming to be your invention. So that particular aspect is covered under inventive step. Inventive step, when you go into the definition, the features which you are claiming as patentable in your application, they should be non-obvious to any person of that particular field. That exact term is person skilled in the art. Okay, so first of all, it should be new, then it should not be obvious for people of those working in that particular art, and then it should be industrially applicable. In layman term, you can understand it should be useful. Like if you are coming up with electroplating through gold for sewer lines, okay, as a solution for corrosion, then that is not a very industrially applicable example. Okay, or if you are coming up with a pencil of length 5 meters or those kind of things. So even though it can be a novel and non-obvious, but even then it is not industrially applicable. So these three are the primary criteria for technical examination. Thereafter, sufficiency of disclosure, which I have already explained, should be there in your description. Then there is a section 3 also, which enlists several inventions which are not patentable in Indian jurisdiction. So it should not fall folly of any of those. Okay. So these are the things which are examined by during the technical examination by the examiner, and then this examiner sends their report to controller, and the controller then generates the first examination report, wherein the gist of the objections is communicated to the applicant, and thereafter this gist is forwarded to the applicant. Applicant is provided 6 months time to reply, and once the reply has been received, based on the substance and merit of that reply, a hearing is offered. If there is an adverse decision, if the application is now found in order for grant, the patent office directly proceeds for grant. But if there are still some pending objections, then under the principle of natural justice, a hearing is offered to the applicant, wherein they come, they explain the invention further. If there are any conflicts, they try to settle them down, they try to amend their applications accordingly, and the application eventually goes for its final stage, that is grant or refusal based on the. So as I've already explained that 2 years is the minimum period which a normal application would take. So the average time as of now is somewhere between 2.5 to 3 years from filing to grant, in case we are not going for expedited examination at all. But this time is also going to decrease drastically, because as of now our office, as sir already explained in previous session, we have already granted 1 lakh patent in the last financial year, and the pendency is almost at 0 levels as of now in several streams. So this time period is going to go further down. So it is at the global benchmarks of the major IP offices. Now, this is one of my last slides, key points for educational institutions. So what is an educational institution is also defined for the purposes of patent applications. And this is defined under Rule 2CA of patent rules. So educational institution means university established or incorporated. So these kind of things. So this definition is quite obvious. So you need to be knowing that this is a legal term, educational institution, as far as patent application is. So you need to satisfy those criteria as enlisted under 2CA. Then the fee is at par with individual applicant, though educational institute being a non-individual entity. So Then if falling under any categories of Rule 24C1, then these educational institutions are also eligible for expedited examination. And there is a separate Form 28, which is required to be filled by educational institutions for every document which is having a fee, that is like Form 1, Form 18. For submission of these forms, they also need to accompany a Form 28 along with. Okay. And it is quite crucial for educational institutions if they want the inventor's name also, because normally what happens is in the letter of patent which is eventually granted, the only applicant's name is there. So if the inventors also want their name in the letter of patent, it is the final grant certificate, then there is a separate form, that is Form 8, required for that. And very lately, that is last month itself, there is a new Form 8A also introduced, wherein the inventors can also get a certificate of inventorship by applying along with the prescribed fee. So these are certain important points which are specific to educational institutions. So
Yeah, thank you.
and these
Thank
are
you.
some, just 1 minute, sir. I'm concluding anyway. So these are some statistics. So you need to understand where we stand globally and how are we proceeding. So if we see for the latest data which is available for the year 2022, worldwide, nearly 35 lakh patents were applied. Okay. And almost half of them, nearly 47%, were filed in China alone. And then nearly 6 lakh in US and in Japan. And for the same term, in our country, we have 82 lakh. So there's a good news and there's a bad news. The good news is that we are rapidly increasing as far as the number of applications in our country is concerned. So from within last 5 years, we have risen from 50,000 to 83,000. And this is going to go further for this year as well. Okay, but if we compare it with the global standards, then we still have a lot to achieve. And another good news is that for the first time in this financial year, the share of residents, that is those applying from India, is in majority, nearly 53%. So that is another. Then as far as educational institutes is concerned, so if you see the last 2 years data, the rise is drastic. So I think that this trend would go on increasing. For 21-22 financial years, it was nearly 7,500, and which has increased almost to 2.5-fold for the last year. And these are several institutes which are top performers as far as patent application in India is concerned. So that would conclude my presentation. If there are any questions, I'll be happy.
Thank you for your address. We have a few questions which our participants have been asked. On behalf of them, I'll raise the question to you. One faculty had raised the question that he had filed a patent and it's published actually, but still he wants to rectify a few things. How can he do that?
Yeah, so it depends what is he trying to rectify, whether these are formal issues which he's trying to rectify, or whether it is substantial issue, that is he wants to rectify some of the features of his invention per se. So there is a form 13 for amendments to your application. So depending on what you are trying to rectify, there are different fees and different criteria. Like if you're trying to do some substantive amendments, then there is this section 57 and 59. As in, there are conditions imposed. You cannot substantially change your invention once you have filed. Okay. So there are restrictions under section 59. Whatever you have originally disclosed, you need to be within the confines of that. If it is more of a formal rectification, that is relatively easy, and that is also done through Form 13 itself. Okay, so I would be in a better position to answer if I know the specific details of the rectification concerned.
Okay. Right. The other question is like, what is the duration from the patent filed to examination? What is the minimum period they can get? And is what a question raised from a student.
So as far as there is another form, I'm bombarding you guys with form. There's a form 9, which normally the publication is only done after 18 months of application, but you can expedite this process as well through applying form 9. Okay, so once you apply form 9, your application will be published immediately. Okay, and thereafter it will be skipping the queue, and your application would be relatively relatively in a better position than those applications which would have normally been published after 18 months. And if you are eligible for expedited category, then the time period is very less. I think within 2 to 3 months, your application would be put for examination. But even in normal conditions, these days, as I've already told you, that we are already almost at zero pendency level in several branches. So even if you proceed normally, just after your publication of 18 months, I think within a month or two, it will be put for examination. You'll be getting a FER, and then the ball is rather in the court of applicant, how quickly they want to reply to it and go with further proceedings.
Yeah. Following to the same question, one more participant had asked, what is from filing to publishing, how much? If they want to you said like it can be made examination expedite in 2 months. What is the cost involved in that? You're asking. How much fees they should pay?
The fees are quite dynamic. I would advise that refer to first schedule of patent rules. Therein every fees is mentioned. So, and it is in a tabular format. So just read the fee in front of Form 9, because I'm not sure whether they're individual entity or whether they're educational, what kind of entity they are. So the fee is provided in first schedule of patent rules, and they are quite clear and succinct. You can go through and easily get the fee for every category. Okay.
So next question is like, we'll take the last question. How many inventor can be in one patent?
There is no limit as such how many inventors.
Okay.
There is no legislative limit as such.
Right, sir. So due to the time constraint, so we'll take the remaining queries later, and we'll discuss in offline, and if you can write to us. With this brief note, I thank Mr. Mishra ji for his time, and in their office they would have been celebrating this World IP Day. In spite of his schedule, he had been given time to us and addressed on administrative and procedure aspects of IP filing in India, and also been addressed on patents, copyrights, trademark, and GA. So, which was very much useful to us as well as to our participants. And thanks for your time and participating and addressing your participants. It has been very informative and very useful information for the teachers, students, and the faculty members participating from school and college. Thank you once again, sir. Thanks for your time.
Thank you. Thank you, Doctor. Thank you.
Thank you, sir. Yeah, thank you. Now I would request Mr. Pradeep, an Assistant Innovation Director in Ministry of Education and Innovation Cell. Brief about Mr. Pradeep. Mr. Pradeep has more than 16 years of experience. Is handling currently in the responsibility of leading strategic innovation initiatives. He's a certified IP professional from WIPO. He's a certified practitioner in startup investment management from IIM Kolkata Innovation Park. He's also an innovation management expert. Pradeep is a consultant for a few MSMEs and startups in healthcare, IoT, IT and fintech domain. So he has a sound knowledge in technology scouting, incubator manager with IPR, tech transfer initiatives. Before his assignment taken at the Ministry of Education and Innovation Cell, he was working as head COV of STPI Tech Park, Bangalore, where he was handling the Center of Entrepreneurship, Corporate and Open Incubator Operation. So with this brief, I would request now Mr. Pradeep to address the participants. Mr. Pradeep, the platform is open to you.
I'm so sorry, I was on a mute. Thank you, Ilan sir. Is my screen visible?
Yes, sir. Go ahead, sir.
Yeah.
It's visible, sir.
Sure. So, thank you, team. Thank you, Ilan sir. All the participants I know You have been taking all this important information since more than an hour. I'll not take much of your time. Maybe I shall cover this points in a 10 to 12 minutes maximum. And for this address, I'll be focusing more on the various IP tools and the project management tools along with the funding opportunities available for the researchers and the innovators. If you see, if you see the overall scenario of the education sector, till date, the education sector was very much classroom centric, domain specific, like electronics, mechanical, civil. On top of that, it is more of the exam based education system, paper based education system, and most importantly, from the student point of view, it is more like a job centric. Means whenever any students come into the engineering and the technology, he used to have one primary aim that after the graduation or the post graduation, he or she is looking for the job. However, specifically after the post-COVID era, the education methodology has been quite changed. Instead of the classroom, the digital mode of learnings has been incorporated and adopted very positively, aggressively. On top of that, instead of a domain specific, now the students and the faculties are learning interdisciplinary domains also, maybe through various platforms of the online. Instead of exam, again, the people and the students are very much focused towards the product development activities also. And few of the campuses, few of the education initiators programs, they are focusing on the product development. And once we say the product development, it is directly leading to the innovations as a center. On top of that, many of the innovators, faculties, students are looking for the startups. So from the job centric to the startup or the innovation centric is the major 180-degree phase shift we people are experiencing. But along with this, dear friends, if you see, if you see the worldwide facts, out of 100 teams, if you consider 100 as a one kind of a threshold baseline, out of the 100 teams, hardly 11.5% of the 11.5 teams are coming up with their out-of-box ideas. On top of that, majorly 3 out of 10 teams are initiating to develop their ideas. And as per the recent WIPO report, hardly 1 out of 10 teams are able to protect their ideas. The reason is quite clear. The people don't know much about the patenting. They don't know much about the technology transfers. They don't know much about how to protect their own ideas for this one. And with the help of this, with this cascading procedures, the overall innovation index is also going to sluggish in nature or decline in nature. So on contrary side, if you see, we as an Indian, we have a major 5 rather 6 abilities comparatively on an edge point. One is the technical ability. We Indians, everyone knows that Indians are having a good technical ability, technical grasping power. Another one is we are very much having a working kind of an attitude. Our analytical and logical skills are quite impressive and handsome in nature. And most importantly, we are very much sustainable towards any roadblocks or the challenges are coming. We do not run away from the challenges and the roadblocks. So we are sustainable, and we used to try to make sure to try to figure out how we can get the solutions against the various challenges. So we have this ability, but as I said, on a contrary side, the innovation index is not that much handsome worldwide facts if you see. So for that, before me, the 2 stalwarts have already spoken about how the IP procedures can be executed. But along with that, friends, you being an innovators, researchers, you can use few of the IP tools, which will help you not only to understand the IP procedures, but to increase the IP related efficiency also. So with this practice, if you see, these are the major IP platforms, which has been proposed by the WIPO. As you know, the WIPO is a World Intellectual Property Organization. The WIPO's TID department, that is a Technology and Innovation Department, they have proposed a few platforms. The first platform is the free of charge kind of a platform. Another one is a fee based. In case of free of charge, if you see the patent scope is one platform, ESCAPE.net is another platform. Where you can have the patent search related to your queries. If you want to understand what are the different patents have been already granted against the XYZ idea, if you have any thought, you can just visit to these platforms. These are the online and free platforms, and you can just understand whatever you are thinking, whether this has been already patented anywhere in the world or not. So you can easily understand with the help of this platform. The lens.org is also one of the good platform available. And at nutshell, the Google is also coming up with one a closed environment, or the closed, I would say, limited type of search engine specifically for the patent, that is called as a Google patent. So this also you can use, which has been very much acclaimed by various the patenting agencies also. On top of that, on the right side, if you see, there are some fee-based platform. If any IP professional or the technology transfer professional would like to understand the various search reports, the various the granted data, or the various IPC modalities, in that case, this fee-based platform is also very much helpful for the startup, for the innovators, researchers, and the startups. The Clarivate Analytics, I think most of the faculties knows about this Clarivate Analytics. This is the most prevalent kind of a platform available, not only for the patent, but for the publications also. Similarly, the Orbit Intelligence, the Patent Inspiration, AICTE and MoE, this is also one of the good platform available. It is on a fee based. Another one is the Patent Insight Pro, the PatBase, the ACE London, Innovation Plus, IP Rally, and Amplified. So you can use any of this platform depending on your interest and all. Some of them are the private sector based, some of them are into the consortium based. Depending on your interest, you can use those platforms for the initial patent search. We can say you can use the free platform for the pre-patentability search also, and you can use this other platform for the in-depth deep diving search for this. Along with that, the WIPO is having one more platform available named as inspire.wipo.int. This platform is specifically for the IP professional, the certified IP attorneys, I would say. With the help of this, you can get the best and the relevant database selection facility. You can get the WIPO's reports and the result database. Earlier, it was available for the IP attorneys, but now they have given this for the certified IP professionals also. So this is just a screenshot I just thought to show you. Based on the various features and the filters, you can easily fetch the relevant database related to your idea or related to your reports. And the Inspire platform, the WIPO Inspire platform is very much active in showing you the various reports and the database relevant to your technology based ideas. If you are into the chemical technology, the respective reports and the result database from the respective country zone or the I would say the continent zone also you can get, and worldwide also you can certainly get from this platform. On top of that, there are few approach we as a layman or the end user, we need to use. For the patent search related activity, you can use a few of the keywords like patent document fields, the basic keywords, dates, names, patent classification symbols, the search operators are the various the query language specifiers. I will not talk much about the search operators. Maybe I'll discuss this search operators in a separate dedicated session related to the how IP search is going to execute for that. But initially for this session, just to understand on a very umbrella level, abstract level, the keyword, dates, name, patent classification symbols you can use for the initial pre-patentability search or the initial patent search, I would say. Along with this, I can change this. I'm not able to. I hope it is visible. Yeah. Here, as I was discussing with you, how you can search. So the Inspire platform, you can use this, and in that you can fetch the information maybe limited to the bibliographic data or the full text, titles, abstracts, claims, various claims also you can easily see from the various results based on the filters, name, dates, classification, symbol, concepts, citations, and the geographical information against the respective idea, so to say. Yeah, so this is one example I thought to share with you. This is a WIPO's application sample, PCT application sample. Friends, whenever you read any WIPO application or the patent application, whether it is a grant, considering it is a granted one. So in that case, major 4 or 5 points you as an innovator, you as a patent professional or the IP professional, you need to look forward. One is the first very most important and the first foremost is the IPC, that is International Patent Classification. If you can see the highlighting cursor, this IPC is nothing but one kind of a categorical classification of the patent and the utility models given by the WIPO, and all the member countries of WIPO is also using this classifications. This classification is made by the Stark-Borg Agreement 1971, and continuously this has been revised also by the respective the IPC committee. So this classification number is very much important to understand related to your patent category, or I would say the patent classifications. Next one is most important is the priority data. Priority data is nothing but the data wherein the first examination report or the first the diary number is generated by the for the respective application. The third one is the applicant name. Who is the actual applicant for the patent? So once you read the results of the patent search, the applicant is very much important. You need to understand who is the applicant, because applicant is the only category who has respective offer or the decision-making authorities against the patent claims. Next one is the inventor. Inventor is supporting to the applicant who is actually involved in the various technological as well as the procedural activities of the patent for this. And the last one is nothing but the abstract. So with the help of abstract, you can easily understand how this patent about and what are the various claims and the benefits available with this patent information. So these are the major 5 blocks I just wanted to share. This is the valid sample published by the WIPO, and I just thought to discuss and share with you with the help of example. Now, moving towards, apart from the IP tools, there are some project management tools are also available for the faculties and the students. If you want to save your time related to the documentation and the various operational activities, the project management tools help you to save your time and increase the efficiency. There are major 5 activities involved in project management tool. One is the task, scheduling, information and the file sharing, communication and the reporting. So for that purpose, you can take a screenshot of this slide. There are major top 10 project management tools available worldwide, and these project management tools are intended for the various project and the program activities. For example, let us say Airtable, Avaza, ClickUp, FreeCamp, Task, teamwork projects. If you ask me, for my department, I'm using very much actively, I'm using this Airtable and FreeCamp like this. You might have heard about the Slack. So we can say based on the Slack, similar to Slack also, the FreeCamp, Flowlu, ClickUp, these are the various project management tools are available. And at initial level, for the students and the faculties, you can use this Airtable, Flowlu, then FreeCamp, Task. These are the various project management tools. These are the features available with this one. You can take a screenshot and you can read later on. The virtual lab is one of the most important, the foremost platform available for all the students and the faculties. This virtual lab is been made by the consortium of the IITs for the various the technological and the TNM instrument activities, that is testing and measuring instrument activities. So virtual lab is also available for all the users. Someone is sitting in, let us say, in Kanyakumari. If you would like to use the TNM instruments and the testing instruments from the IIT Delhi or maybe from IIT Bombay, along with the virtual lab facility, he or she can use. So this is just a platform available for the virtual lab. You can use this, and the participating institute or most of the IITs are available with this one, and this is completely free in nature. Padlet is one of the most important activity. Dear friends, from the IP to the technology transfer, we need to share lots of information under the TTP model. So for that purpose, the Padlet is also one of the best, I would say, the technology information sharing or the virtual bulletin board kind of a platform available for the students and the faculties. In a team also, you can use this platform of Padlet, wherein you can collab your ideas, brainstorming models, and whatnot actually. So let us say one example, if someone is working on the 3D modeling part, and if the 3D modeling related the files, if you would like to share with his team members, this is a kind of an Padlet bulletin board. He or she can share the information along with this 3D modeling part, and other persons can easily work upon those 3D modeling part, and they can put their all the revisions over here. So you can use this Padlet also. If anyone is working on working in a big team, let us say of a 10 members or 8 members, in fact in 5 members also, you can use this facility. For software persons, the IT persons, everyone knows about the GitHub. For information sharing, the technology-based information sharing, the algorithms and the software codes, we can use the GitHub as one of the best platform to share. The most important and the handsome feature of the GitHub is it has a version control facility. So whenever you do any changes in your software code, it keeps records of the respective version controls over here, and you can keep all your code in a one place, so that the software engineers or the IT professionals can keep track of the respective code revisions for this. Okay, so I would like to discuss about the funding opportunity. Ilan sir, can I have 5 minutes to discuss on this funding?
Yes, sir. Just quickly, sir, 2-3 minutes. We can wind up in 2 minutes.
Understood. So, friends, there are some funding facilities are also available for the various projects, whether it is IP-based project or the technology transfer-based project or the startup project. So this is the funding opportunities available from the government side, the various departments of the governments. The Software Technology Park of India is also promoting the startups and the innovators for their ideas. DSTs, everyone knows about the DSTs, DST call of applications. Ministry of Electronics and IT is also having their own MIT Startup Hub facility, and they are giving the funds for this one. And Niti Aayog's AIM portal, the Ministry of Environments, then the ICAR, Science and Engineering Research Council and all. But friends, along with this government, I would like to highlight, I would like to take your attention towards this one. This is called go-directory.nisa.in. So this is also very good facility available wherein you can have the search results related to the various funding agencies. And apart from that, ICMR, CSIR, DBT, ISRO, as we knows about this one. Along with this, there are some international funding agencies are also available. The fundinggops.cost.com, this is a kind of a search engine available wherein you can get more than 4 lakhs of funding opportunities related notifications over here. And collectively, if you see the outlay, more than 33 billions of the outlay is available for this one. So you can, if anyone would like to go for the international funding opportunities, you can use this funding gops. Next wave sciencemap.org, it is an European based grants and fellowship related platform. Researchmala.bc.ca, it is a Canada based platform available for the external funding, and you can get the funding database related to social science and humanities over here. SARN, that is South Asian Research Network, is also available related to the social science and humanities. TRAM is the most prevailing and I would say the most popular kind of an funding agencies available specifically for the engineering and technology groups or the students or the faculties. This IHRQ is specifically for the healthcare sector. Whoever is working in the area of healthcare, you can use this health research quality based funding agency. This is a European funding agency. If anyone is working in the healthcare research, PhD or maybe the MTech students, you can use this facility. Last one is the Ford Foundation. They are also coming up with, they have also come up with the various funding facilities available for the innovation in the automotive sector. Okay, so this is from my side. Thank you very much. This is just, I felt these are the most important link available from the MIC side if anyone is interested in the same. Thank you very much. Thank you, Vilan sir. Thank you.
Thank you. Yeah, thank you, Pradeep sir, for your address and highlighting on the patent database search tool and patent search approach. It is very informative. I'm sure it has been useful to our participants who have been and they can use this tool on for their daily day-to-day activities and the patent search. So now with this brief, I also will take a quick 5 minutes of your time to brief about what Kapila scheme is doing and how it's going to benefit as a part of World IP Day. So Kapila scheme has been launched by Ministry of Education and Innovation to support the colleges, faculties and students with the funding support for their filing patent and examination fee. So Kapila is to recognize, facilitate and felicitate the IP innovation best practices in higher education institution. Through this scheme, we used to fund for filing and examination fee. Before Kapila, it was the filing fee was 8,000 rupees and 20,000 rupees for academic institution. Now we, with the support of Control General of Patent Office, we have returned to Ministry and we have reduced the fee for about nearly 80%. Now through this Kapila scheme of Ministry of Education, Innovation Cell and AICTE, we fund up to 40 patents per institute. So I would, at this occasion on the World IP Day, I would request all the participants who have been participating for this event to get benefit out of this scheme, so that through your institute you can file 40 patent and from AICTE and Innovation Cell, we will reimburse the filing fee, which will in turn, as Professor Rao sir had said, that we have touched 1 lakh patent granting in this financial year. So we can also stand in many more better position with all your support of patent filing with the support extended from Ministry. So what you are supposed to do that you should form a Kapila committee. It's all in the reimbursement mode. The patent filed after 15th October. It's on World Innovation Innovation Day, which has been celebrated in India, and we reimburse this fee of examination and filing fee. We request you to upload the receipt of filing and examination fee, and you can upload the statement of expenditure document which we given. We will validate through the 12-digit application number which you have been submitted. The committee should be approved by the host institute. We also jointly with the Ministry of Commerce and Industry and through an IPM program, we used to conduct an awareness program. Those who have been interested, you can always write to us so that we provide a certificate to the institute as well as to the participant to participating in this NIPAM program. Through Kapila, we have introduced an IPR course. I thank Professor Rao sir, who has been part of an expert committee here, and as an expert speaker, sir is the chairman of this IPR committee. Sir had been drafted this introduction to IP course for UG and foundation of IP for PG, and intellectual property and innovation for PhD. This course is being developed, and we developed a Swayam course for the UG students. It's a 3-credit course which we know the credit transfer is done through IIT Kharagpur. So this is second year where we had more than 13,000 plus participants who had registered for this program. So this date was closed on 8th of February. Again, we'll open it in June. If someone has been interested, you can enroll and get this certificate from Swayam as a 3-credit course. How to register on the Kapila portal? Just log in through kapila.mic.gov.in. You validate your institute as a code. You validate it. After validating, you are supposed to form a committee with the members, with the 5-member committee. You can validate the institute will validate their committee. After that, you can enroll your IP details. You can upload it. So you can do a file the patent. After filing the examination fee and filing fee, you can upload it on our Kapila portal. After uploading it, within 2 months' time, we will reimburse the filing and examination fee. So I am happy to convey at this occasion that because of the Kapila initiative jointly with Ministry of Commerce and Industry, today the filing fee and examination fee is reimbursed, and the patent filing in the country had increased in the academic institution with 267% of been increased in the patent filing. I'm happy to share this at this occasion, and I also want to convey you that every individual contribution will make our country to stand a better position in the Global Innovation Index. In 2015, we were at the 81st position in the Global Innovation Index. Today, we are at happy and proud to see our country standing in a better position. So, with all your support, we'll see to that our country stands in a better position Also, for any queries, you can always write to us at kapila@AICTE-India.org. And you can join these Telegram groups for any doubts required related to Kapila scheme or any other IP related issues. You can always join in this group, and you can ask your question to us. We are here to open and answer your question. Also, there was a question asked in the chat box. We have been going through it. A student had asked whether there's a fee which has been for a patent to be identified and registered. I want to convey to that participant that the patent fee and filing and examination fee is a government fee, which the 1,600 is a filing fee and 4,000 is the examination fee, which is in general to be paid on the portal of the government website. There is no separate fee which is required beyond that. So you can get benefited out of this Kapila scheme. Thank you once again for everyone joining. As a formal vote of thanks, I thank our expert speaker, Madhusudhan Rao from IIT Delhi, and so also I thank Sir for his continuous support for Ministry of Education Innovation Cell, and especially for the Kapila Committee. As a chairman of a Kapila Committee, Sir had supported in developing the 3 cores. Thank you, Sir. You're always kind enough to accept our invitation in spite of your busy schedule, and supporting us in different initiatives and guiding us in implementing this IP initiative. Thank you once again, sir, for your time. And I thank Mr. Mishra Ji from the Patent Office who had accepted our invitation and briefed our participants about the importance of patenting, filing, and also he had briefed the procedures and administration guidance. I thank Mr. Pradeep, our Assistant Director from the Ministry of Education Innovation Cell, who had addressed about how IP helps in technology transfer, and also the IP tools which would have been benefited and would have been given a path to you all as a direction of how we can search and identify your patents. And I thank our director, Mr. Yogesh Barmankar sir, for his support in executing Innovation Cell initiatives. And also I thank my team, Mr. Amit, Mayur, Shiv, Arsh, and Dr. Pooja for their continuous support in successfully executing all the innovation initiatives and the school initiative. With this brief, not last but the least, I thank all the participants across the country have been participating, more than nearly 400 plus participants in YouTube. I also got a lot of photographs where the schools and colleges had played this in their auditoriums and in the classrooms, and I was able to see a group of students sitting in the classroom and listening to that. So I'm sure it was being useful to you. Stay connected with us. We also try extending our support for patent filing for the school students and teachers. Shortly, it will be updated on the Kapila portal. Once again, thanks for everyone time for sparing with us for past 2 hours, staying connected with us. Thank you all.
As you have thanked everyone, Dr. Ilan, I thank you for organizing this important and productive session on the occasion of World IP Day. I appreciate and I congratulate your efforts, your team efforts. Thank you.
Thank you, sir. I also know since the World IP Day celebration. I hope the next year, whatever Professor Rao sir had said, 1 lakh, we'll try our best to increase the number. And for every individual contribution makes our country to stand in a better position. With this word, I also want to say that nothing in life is to be feared; it is only to be understood. So no need to worry about how to patent, how it is. It's no whether it's any gray area or you are worried about it. No need to worry. There are a lot of opportunities and supports and funding available for you from starting from idea to patent filing to product development. Make use of those things and make our country to stand in a better position in the upcoming year. Thank you once again. Thank you all.